Good morning. I'd like to call the May meeting of the Kansas State Board of Education to order. Welcome, everyone. I would especially like to welcome Dr. Mary Skaggs from Baker University and two students who have been student teaching this semester. We're always so pleased to have students here because we value their commitment to education and like to see their faces and encourage them in their careers. So welcome. Oh. And Carolyn Campbell notified me that there are two students from Washburn University present today, sitting in the back where I can't see them. So you all can see them, and we welcome those students as well. She tried to get them to come up front, but they wouldn't. Okay. All board members are present today, and I would like to announce that if anyone present happened to park in a parking slot that had a green bag on it, those spots are reserved for board members, and one of our board members had to park elsewhere. So if anyone is parked in that place, it would be nice if they might move their vehicle so our board member can have benefit of the parking. I would like to read the mission of the Kansas Board of Education: to prepare Kansas students for lifelong success through rigorous quality academic instruction, career training, and character development according to each student's gifts and talents. Now, if you would join me in a moment of silence to begin our meeting. Thank you. We'll stand now for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The first item on our agenda is to approve the agenda. There are no scheduling changes at this time. However, there are 3 revisions to the consent agenda items that I would like to make you aware of. Item 19H, the single licensure waiver request on page 257 has been withdrawn. It will not be considered. Item 19K, page 267, a finalized list of school breakfast program waivers is in each board folder. This replaces the draft in the board packet. And item 19N, school improvement grants, page 275, we will only be considering the continuation grants. The applicant for the new grant funds has withdrawn. The board will consider another recipient at a later time. So those are the revisions to the consent agenda. I would ask for a motion to approve the agenda at this time. Moved by Dina Horst, seconded by Carolyn Campbell. All in favor, raise your right hand.
Madam Chair?
Yes.
Can we discuss? I wanted to move that we move item 19I for discussion unto itself. If 19I was not one that changed, I would like to pull that away from the consent agenda for future consideration.
Thank you. I'm sorry I didn't see your name here, and I didn't mean to ignore you.
Okay, it was 19I, Madam Chair.
So Steve Roberts has requested that we remove item 19I. Was that correct, Steve?
Yes.
Pull that from the agenda. So, Dina, would you revise your motion to include that? Yes. And Carolyn? Yes. All right, so it's been moved and seconded to approve the agenda with the exception of item 19I on the consent agenda. All in favor, raise your right hand. Opposed? The motion carries. We need to approve the minutes of our last meeting. Do I hear a motion to approve the minutes as included in your packet? Yes. Okay. Janet Waugh moves and Sally Cobble seconds the motion to approve the minutes. All in favor, raise your right hand. So we approve that by a 10-0 vote. We will begin our meeting with the Commissioner's report. And this is kind of a nostalgic minute for all of us because this will be the last report we will hear from Dr. DeBacker.
Yes, it is. First of all, I'd like to thank you all for the reception yesterday. It was very humbling and touching, and it was filled with friends and coworkers and family, and thank you all, because I know you contributed to it, to Peggy and Denise and Penny. They worked very hard getting it together, and so did some of you, so thank you. It was hard to get to sleep last night, so thank you. Thank you for a sleepless night. Board report. Seems only appropriate that the timing worked out to update you on your board goal and your mission and your objectives. We do that every quarter, so we're really about a month early, but for me, it's a way for me to have a little bit of closure with this board before I move on to something else, and hopefully celebrate with you the accomplishments that we have been made by you as a board, by as a staff, and by Kansas educators in meeting your goals. Just to remind you, you set a mission, goals, and objectives every other year, and you do that after the election of possible new board members. So you set these in 2013. You set these after 4 new board members came on board and Mrs. Campbell was reelected. Typically, we let the January meeting happen, and then in February, you do a 1-day retreat, 1 or 1.5 day retreat, where you look at your mission and your goals and objectives that had been prior to that time, and revise them and update them. So you work with those for 2 years. Many times, some of those goals carry on, because they're just goals that are very important for education. Sometimes you add a new goal, take out a goal. So this is what you've been working with as this current sitting board. Next year, next February, you will most likely be somewhere for a day and a half talking about this topic again with somebody leading and helping you with that discussion. Whether or not there'll be new members on the boards yet to be seen. We have 5 members up for re-election, and they each have will let you know on their own terms and times as to whether or not they are running for re-election. So we'll let you visit with them in the next coming months. What we do, you set a mission, and that mission is read every board meeting that establishes what we want to happen in education as a lofty goal. And then you set goals And usually we try to limit you to no more than 5 to 7 goals. Otherwise, get a little fragmented in what we're trying to do, and focus is very important. You have 5 goals now, and then you set objectives. And you say, in order to meet this goal, here are certain things that we think we can do to do that. So that's where the board ends in terms of setting a mission, goal, and objectives. It's then up to the staff of the agency to take it down to the strategy level. So what are the actual things that we're going to do to help you meet that objective and that goal? So what you have in your packet, beginning on page 28, is my take on how I think we're meeting these goals. You've seen this before. Whether or not Brad, as interim commissioner, will use this same format, I don't know. But this is I try to give a visual of how I think that we're meeting the goals with your work and our work. So on page 28, you see that chart, table actually, and you'll see some colors. Except for those of you who may be colorblind, I apologize for that. You'll see some grays and some light colors in there. Everything that is green, I think we're hitting the mark on with an effort of at least a 9 or a 10. So on a scale of 1 to 10. And that is from my perspective, from the work that we see here in the agency. So you're going to see quite a few greens, and that's a good thing. Quite a lot of work being done on the objectives that you set out for us in your goal number 1, where we have a flexible delivery system in order to meet the needs of all kids. Your first goal was, or your first objective was, to encourage the implementation of tiered instruction. In our world, that's MTSS. We're at a 9 on that. The people working with MTSS, they'll tell you they are at a 10 plus on that. But I rate it as a 9 because not every school uses MTSS yet, so we still have a ways to go. Just to remind you, MTSS is not a mandate. It is not a program. It's a way of doing schooling. It's a way of doing business. It's a way of doing instruction. So it's not a program. It's not something you pull off the shelf and out of a box. And so it's voluntary. We work with schools that want to implement it, and so I believe we're at a 9 in that one. In your second objective under that flexible delivery system, to continue to move forward to a new accreditation model, I have that at a 7. You have a work session tomorrow afternoon talking about that system. We're calling it Accreditation 101 based upon the questions that you gave us a few months ago. It made us realize we had done nearly enough work with each of you to bring you up to speed. So I have that as a 7. That's kind of we're hitting it, but we're not going at it full force. Anytime you see a white one, that means that the effort is below 6. That's not necessarily bad. It's just that in that particular objective, we have not, as an agency, worked as diligently on it. And so this one is to improve graduation rates, improve graduation requirements, or review those, and reduce dropout rates. Now, that's happening in districts. You have 2 superintendents sitting here who tell you that they're working every day to increase graduation rates and reduce dropout rates. But from the state level, from any initiatives that we're putting into place, any policies that you may have done, we haven't done anything on that. That's why I give that a 6. Still work to be done there. In your 4th and 5th objective, one's all about career and tech ed, and the other one's about the ESEA waiver. They both get 10s. You know that the work in career and tech ed is going full force. Senate Bill 155 helped you with that initiative, but definitely a 10 from our effort on both of those. And the teams here have been working on the flexibility waiver nonstop, and we will continue to do that. Your last objective under that first goal is to encourage use of technology in education delivery. Again, I put that as a 6. It's not because it's not happening in schools. It's just that from our level, from policy level, from state level, we've done nothing in that area. In Goal 2, providing an effective educator in every classroom, you're going to see several greens and yellows and a couple or only one white. First one is to identify and reduce unnecessary barriers for teacher licensure. you need to be proud of the work you've done in that area. Later today, you will have a action item in front of you to approve 3 areas of licensure that you have all felt for several years have been barriers: career and tech ed, direct entry special ed, and out-of-state licensure. It's a move in the right direction. Do we have it completely nailed down yet? Probably not. House Bill 2506 introduced a few other things to consider there, but for what you have been considering the last several months, I believe that's an effort of 9. Your second objective of continue to develop strategies for teacher recruitment, support, and retention, I give it a 6, again, because we haven't really put anything on the table for you to consider as far as policy or as far as initiatives from our agency. 2.3, assist schools with implementation of the effective evaluation of educators. That is KEEP. That is Principle 3 of our waiver. It gets a 10. We're working very hard on that, and districts are working hard on that. Remember, they did not have to implement the KEEP system. They could implement their own evaluation system as long as it met certain criteria, and a lot of work's being done with that around the state. Gets a 10. Revise and review teacher prep programs. I give it an 8. Doing a lot of work with higher ed, talking about what changes we need to make so that the young folks who are sitting out in the audience today, I understand 2 of those have jobs already. Is that right? Yep, 2 of them already have jobs. The others, I think, are still studying. But making sure that the preparation programs that they're going through, whether it's at Washburn or Baker or wherever it may be, that those programs, the first day that they enter their classrooms are prepared. And we're working on that. I think we can continue to work on that even a little harder, but it does get an 8. Your last 2 in effective educator is identify flexible licensure requirements in CTE, obviously a 10, and then review the special ed, obviously a 10. Your third goal is making sure that we have a visionary leader in every school, and you had 3 objectives under that. And I am disappointed that 2 of those 3 are not, there's not a color with them. I mean, they're 6 or below. The first is revise those teacher preparation programs. We have not worked as hard or as diligently with higher ed to do that. And we have not developed any strategies for retention of our future leaders, not much. We do some work through Kelly, the Kansas Educational Leadership Institute at K-State, have beefed up once they get into the program, but certainly not doing much in terms of trying to recruit more people into leading our schools, which is very important. But your third one of assisting districts in implementation of the effective evaluation of leaders, that's that Principle 3, that's KEEP or the McCrell system or the Southwest Plains evaluation system, it gets a 10. Your fourth goal was a new goal for you that you implemented when you set these goals up, and that was to promote and encourage best practices for early childhood programs. Remember, you guys had a long discussion about this because your charge through the Constitution is K through 12 education. And remember, we had quite a bit of discussion about, do we go down to pre? Is that really where we should be doing our work? And as the majority of the board, you said, yes, it's important that we have some influence on what happens in early childhood education before they ever get to our doors. So you put that goal in, you'll notice that there's green or yellow on all of those, with the very first one being define early childhood education. We did that right off the bat. I told you, I was very honest with you back in February of 2013 that was a gimme. We already had that defined, but it was fun to be able to bring that up and say, here's what we've been working on, and here's how we define early childhood education. The next 3 goals that or the objectives that you have there about making sure we know what research determines best practices, that parents know what access they have, that they identify relationship with other organizations within their communities that provide early childhood education, and that we advocate for universal early childhood education. Those all get a 7 or better. And actually 4 should be coded as a green. We did have a special committee on kindergarten during the legislative session. did not lead to any action, but I can tell you that the conversations that happened, the discussions that happened, the people that appeared in front of that special committee to talk about the importance of all-day K and early childhood education, that discussion will be immensely helpful to you as you move forward on this. No action doesn't mean that nothing will happen and that we haven't changed some of the conversation. It simply means it's not ready yet. So I'm really proud of the work that you did in that. I'm proud that you put that as one of your goals. Your final goal was to actively communicate and collaborate. This board has no trouble being active and being visible and having opinions and lending to the conversations, and what a great gift that is for the state of Kansas, that you do that you take your elected roles and your responsibility to K through 12 education very seriously. So we've talked about aligning that pre-K through 20 systems of support, the work that we're doing with the Board of Regents, with the collaboration, or with our integrated agency committee is very helpful. You're educating the public on the issues. What you did with the mailings of the postcards all during the legislative session, giving little snippets of what education's all about. Those are being used and they're being referenced. So that was an excellent decision by your communications committee and work by Peggy and Denise to get that going. And finally, develop strategic partnership with stakeholders. We do very little alone. We do not work in a silo in education, and every other agency works with us. You saw yesterday some of the people that showed up at the reception that other agencies here lending support, and that is because they know that we're all in this together. So that kind of gives you the at-a-glance view of what you've done. All of the information that's from page 29 through 46, those are the details. Those are the strategies. Those are the things that mainly Brad and his staff have done day by day, week by week, month by month, in schools and in districts to make this happen. So if you really want to see why I, rated your 1.1 goal as a 9, if you look at what's under 1.1 and everything that's been done, you can see that. This is by no means an exhaustive list. It will never be done. We'll never get everything captured on what's been happening, but it does give you a glimpse of how we're working to meet what goals you set. And what we believe is the direction of education in the state of Kansas. So that is my final commissioner's report, and I stand for any questions.
Before I ask for questions, I just had a comment, and I was going to do this at the end of our meeting, but I think it's an appropriate time now to thank our commissioner for her service. Diane, your focus on moving forward with our goals has really been exemplary, and we appreciate the way you have helped move us forward, given us the support, communicated with the legislature, with the field, and on behalf of the board, I want to thank you so much for what you've done for education in Kansas.
It's been a pleasure. Thank you.
Now, I need to look and see if we have other comments here. Does anyone have questions or comments for the commissioner in regard to our goals or moving forward? Okay. Well, thank you.
You're being very nice to me on this last. Appreciate that. No, thank you.
You're good.
Well, it's. I think we can go ahead and open it up for our citizens' open forum.
I think
We're a few
the
minutes
cards
early.
are over there. A few people.
Oh, we have some.
We do have some, yes.
I didn't have them in hand, so I.
And we're a little early, but as long as we keep it
Yeah,
open
and there
till
are
10:30,
people
you're fine.
here. So I would like to declare the Citizens Open Forum of the Kansas State Board of Education meeting open at 10:25 a.m. The State Board provides this opportunity for citizens to share views about topics of interest or issues currently being considered by the State Board. The State Board asks that speakers identify themselves by name and the name of the group they represent, if applicable. The State Board also asks that each speaker focus their remarks on issues or topics. Personal attacks will not be tolerated. Each speaker shall be limited to 3 minutes. Any board questions will be for clarification. Our first speaker is Dr. John Morton.
Good morning, board members. I'm here wearing my Emporia State hat today. I mentioned this conference to you before. I have a reminder flyer. We are hosting a drive-in conference on Friday, June 13th, called Common Sense About the Common Core from 10 to 4. State board members have been invited at no charge to attend if it works in your schedule to attend that day. We think it's going to be a very meaningful conference for schools that choose to attend, because we're hoping to use this as a springboard to create dialogue groups at various levels that will continue discussions about Common Core implementation as it continues. We have been involved in an endeavor. We have written a short ebook that will be provided to each attendee called Common Sense About the Common Core, several of us at the university. We're just looking forward to this as an opportunity to really bring practitioners together, dialogue, talk about the kinds of things that are involved, and hopefully provide some helpful direction as schools continue to grapple with this rather massive transition. So please feel free. If you are interested in attending, the registration site is down there below. If you go to that and just let them know that you're a state board member, they will put you down on the attend list for that day. It'll be at Visser Hall on the campus at Emporia State. Secondly, very quickly, I want to thank you on behalf of the 3 service centers that I have represented this year. I provide them instantaneous feedback on board meetings. We have been trying to increase the visibility of the school service centers in terms of their willingness to, I think, partner with the board, with the State Department in terms of making those kinds of things happen. So I've been working again this year with the Smoky Hill Service Center, South Central Kansas Center, and ESDAC. They've come together and collaborated and partnered to try to provide better information to superintendents and other building administrators and teachers about the actions of the state board, and try to maintain that dialogue. And I've appreciated your acceptance of me in that role, and look forward to working to you with that again. So please come join the dialogue on June 13th if you can. Thank you.
Thank you. Our next speaker is Tom Krebs.
Well, good morning, Madam Chair and members of the board. On behalf of KSB, first of all, I want to thank you, Commissioner, for your great service to the state. We've enjoyed working with you, and so many times, you know this, whenever we ask Diane to come and be part of a KSB seminar, she makes every effort to be there and talk about what you're doing. So thank you for all that. We appreciate it. I am here to talk about some things that we've got upcoming. We've got a series of 3 meetings, and the first one start, I believe it's next Wednesday, but we have 3 sets of meetings. We have advocacy meetings, which are essentially for school leaders, that we're going to talk about the legislature and its activities, and Mark Tallman will be doing that. And we're also going to have, in conjunction with those 24, not at every site, and Peggy's got a brochure. I'll have some hard copies for you tomorrow, but she can email you a copy if you are interested and get dates. That we are going to have, I think it's 12 legal seminars. No doubt that the legislature created some concerns about upcoming changes in due process, the student data privacy law, Senate Bill 367. So we're going to have a legal update. And then what we're also going to do, we're going to have, I think it's 12 of them, we're going to have candidate briefings to which we've invited all candidates to for House of Representatives, State Senate. There are a few State Senate spots open, U.S. seats, and board members. And at this point, Sally's been the only one who's received the invitation because she's the only one who's filed. But we'll be bringing candidates up to speed on what's going on in education. So we want to share that with you. We also want to make it clear that we've got other big things on tap. We will be having our summits in the fall, and we're frankly just going to try to really make our school leaders and their communities really clear about what's going on in education across the state and what they can do to make their schools and their districts as effective and efficient as possible. So I'm just here to share those activities with you.
Thank you. Our next speaker is Diane, got to get my glasses on here, Titterington. I didn't say it right.
Actually, you did pretty well.
Okay.
Good morning. My name is Diane Titterington, and I am a health and physical education teacher at Tonganoxie Elementary School in Tonganoxie, Kansas. Thank you for the opportunity to speak this morning. This past year I was selected as the Kansas Health Teacher of the Year and our 9-state Central District Health Teacher of the Year. I am a full-time, pretty much health teacher. I do teach a little bit of PE at Tongi, but this position is rare among most schools in Kansas and even in the United States. But I wanted to share with you why this early health education has been of such great importance and value to our students and their families, and why I strongly believe that other districts should consider doing the same thing. By getting an early start in health education, my students are getting a good solid foundation of many of the anatomy and nutrition and how to be healthy and safe. By the time they leave, they will have over 4,000 hours of, minutes of quality health education lessons. In the state of Kansas, we just basically require at the elementary level mandate that elementary schools teach health and hygiene. There's no other guidance on that or details. And then we're in the PE, one unit of PE where you will have instruction in health and human sexuality. Several other states, California, New Jersey, Delaware, North Carolina, Missouri, they require health to be taught in almost all grades, especially K through 9. Although the amount of required time varies, they all recognize that an adequate, comprehensive health education program is essential to continually improve the quality of public health education in their states, and that it can be effective in prevention of disease and disability. There is a very great need for much more quality, comprehensive health education at all grade levels in our state and in our country. Students need the keys to living healthier lives and in making wise, healthy decisions. I believe the keys need to be given to them at a much earlier age, beginning in elementary school and continuing on through regular health lessons throughout the middle school and then on into the unit in high school. They need to have a strong health foundation, not just a smattering here and there. By the time many students get it, it's too little too late. One huge additional benefit is that a great rapport is formed between a health teacher and the students, as well as with their families, as I have seen at the elementary school there at Tongi. A mutual trust and respect has had a great impact on the family's health and on the decisions that students and families are making. Parents often tell me how much they appreciate all that I'm teaching to their children. The health classes that my students are receiving now are making a difference in the personal, family, and community health of Tonganoxie. 5 years ago, less than half of our students were wearing seatbelts on a regular basis. Now, 80 to 90% and almost 100% of my fourth graders at a regular basis are wearing them all the time. It's one thing I check with them all the time. I know that many more parents are also wearing them. Just the other day, a student told me that his dad wanted to thank me for teaching him about drugs and medicines and all the other stuff. Parents often jokingly tell me that that I got them in trouble the other day because their son or daughter told their mom that they weren't eating a very healthy meal that night, and then would explain to them what was wrong with it. One of my goals is for not a single one of my students to ever use tobacco or illegal drugs. I know that's a lofty goal, but that is my goal nonetheless. I hope to track them through their middle school and high school years and to keep encouraging them to always do the right thing for themselves and for others. Quality health education is so important and is so badly needed in all grade levels and of our schools, and it needs to start at a very young age. We need to give them the keys. We need to get them going on it at a early age. Thank you for letting me come and share a little bit of what I do at Tanganaxie Elementary School and the value of health education classes. And thanks for all you do.
Thank you, and I believe we have a question. Steve Roberts.
Yes, thank you, Madam Chair. And thank you for your service, Ms. Titterington. An open-ended question. Feel free to pass or punt or embrace it.
All right.
Which is closer to describing your situation in Tangi? You fill the position, or the position fills you?
Are you talking about?
You are hired to fill a position. And that's typically what we do, is we hire people for a position. But I'm just curious if you would have...
It kind of happened together. We saw the need, and we developed this position at Tanganaxie Elementary School about 5 years ago. And I do it out of a love for the children. Is that what your question is asked? I do it out of love for children. The physician, I love teaching health. I do it because I want to be there. And the position fills me, I guess you could say. I don't just fill the position fills me. This is my goal, to work with the children and to help them to live healthier lives.
Thank you. I think we're lucky to have you.
Yes.
Thank you.
Thank you.
Our next speaker is Katherine Johnson.
Morning, everyone. I'm Katherine Johnson. I'm an attorney with the Disability Rights Center of Kansas. Really pleased to be here today. This is my first time having the opportunity to address you in your new space, and it's very, very nice. I want to thank you for adopting the ESI regulations back in February of 2013. We had a lengthy discussion about that, and we're very happy and pleased with the board's interest in these regulations and continued commitment to amending them to make them stronger. I'm here today to share with you DRC's perspective on the current regulations. But before I get to our current perspective, I want to take you back a little bit in time. In February of 2013, Rocky Nichols, who's the executive director of DRC, proposed 3 needed changes to the board to make the regulations stronger and address the concerns that we in the disability community were seeing. Those 3 concerns were enforcement and investigation by KSDE, proper training by staff, and specific use of the standards for when ESI could be used. I've attached Mr. Nichols' testimony to mine so you can review that. During the past year and a half, DRC has worked very closely with KSDE to address the 2 later concerns, the use of ESI and the training. During the February 13, 2013 discussion, the board diligently acknowledged the need for a parent to have a review after the local decision has been made by the school district. DRC commends the board for their insight into why a parent would be concerned about having just one review at the local level and not having an opportunity for further review of that decision. What we have seen in DRC is that complaints continue to come to us. We have a great number of people that call with special education issues. I do quite a bit of this work in my office, so I feel pretty comfortable telling you kind of the range of issues that we're continuing to see. They range from what is considered a seclusion room, time spent in the seclusion room, use of restraint, documentation that a parent is given, and a general lack of understanding of first off, the local complaint process and what other avenue there might be for them to complain about what has happened to their child. They remain very concerned about having a need for a further review of that local level decision. DRC has worked very hard to advance the board's request for language on an appeal process. We've collaborated with General Counsel Cheryl Whalen. We've developed a dispute resolution process for consideration. The idea behind this process allows two things to occur. One is an independent review of the parent's complaint, and that the parent complaints still start with the local level. We've shared this language with KSDE and with SEAC, and we stand ready to work with SEAC in July when they address this issue, and stand ready to help in any way we can to bring this issue forward. I see my time is up. I would certainly stand for any questions. Thank you, everybody.
Thank you. Did we have any further participants? Okay. So I will declare the State Board Citizen Open Forum closed at 10:39 a.m. We would like to thank our speakers for sharing their views with the board. The State Board will determine if any issues should be addressed as an agenda item at a future meeting. Thank you. Well, we're a little early, which is a good thing. That gives us a little more time for our next agenda item. We are ready to receive the staff and board attorneys' reports on the McPherson.
Would like a quick break before you start that.
Oh, really? Oh, okay. Well, I've had a request for a break from some of our board members. We will take a, how long do we need? 5 or 10 minutes? 10-minute break and reconvene at 10 minutes until 11. Thank you. It appears that our board members are returning to the table, so we're ready to move on with our next agenda item, that being to receive the board attorney and staff reports on McPherson and Concordia Innovative District applications. So I will turn it over to Dr. DeBacker.
Thank you. On pages 49 through 122, you'll find information on the innovative district applications that have been presented to the State Board of Education. Just a real quick recap, beginning on page 49. Last month, the State Board asked us to do a couple things. They asked the staff, the KSDE staff, to review the applications to see if they met the technical requirements as defined in the law. And then the second thing you ask is that we have we kind of weigh in on what rules, regulations, exemptions the two districts are asking for, and how those exemptions, if they can be approved or not. So it was really a two-step process. One was really upon the staff to look at the technical requirements, and then the second part was a combination of staff, the board chair and vice chair, along with Mark, looking at the whole legal aspects of it as to whether or not it meets law. So I'll begin with the easy part, and that's whether or not the applications met the technical requirements. On page 49, you'll see that there were 5 areas that the applicants had to address in their application: description of their program, description of parent and community support, specific goals to be and outcomes to be obtained, how pupil performance would be measured, evaluated, and reported, and finally the 5th area, description of what state laws, rules, and regulations from which the district is requesting to be exempt. So 2 applications have been received by the State Board of Education in the process that was outlined in the statute. Those 2, McPherson USD 418 and Concordia USD 333. Both of those applications are included in your packet. Again, for your review, you had those last month as well. So in terms of the technical applications, both school districts met the requirements of talking about those 5 areas within their application. So in terms of your first question, did the applications meet the technical requirements? It's the opinion of KSDE staff that they did meet the technical requirements. So then we get really to the bigger question of what rules, laws, what do they want exempt from? And so we outlined that at the beginning at the bottom of page 49 and then running through page 51. Beginning with the McPherson School District, they asked for an exemption from the use of state assessments. And then they went into great detail as to which assessments that they wanted to use at each grade level. And you can find that in their application. Our opinion, the KSD staff, is that the request to use assessments other than state assessments for state and national accountability is not possible. In grades K through 2, you can use anything because those aren't defined by federal law or state. But in grades 3 through 8 and once in high school, those are approved by the U.S. Department of Ed, at least in the areas of math and English language arts. This is not a new topic for this board to deal with. It's not a new topic for McPherson to deal with because they were the trailblazers in asking the U.S. Department of Ed for an exemption from those state assessments, and were denied that partially. We're allowed to use the ACT at the high school, but everything else was denied. So it's the staff's opinion that you as a board can't approve that. It's a federal accountability requirement. You do not have the authority to waive federal law. And we've seen that before with McPherson, Kansas City, and now Turner asking for their waiver on assessments and weren't granted those. So we see that. McPherson also asked vaguely that they may eventually seek consideration from teacher licensure, food service, in-service, and regents. No specifics were given about those waiver requests, so it's our opinion that the state board, you can make no determination on these until you know what specific has within those. So in terms of the McPherson application, the state board or the state department's recommendation is that it must be denied as presented. One, because it's federal accountability, and the other is because of the vagueness of the others. On the Concordia application, Concordia asked for exemptions in 4 areas: licensure, accreditation, new pathways, and local credit. All of those are contained under quality performance accreditation, or QPA. And so the dilemma that we had even as a staff is that as you look at the bill that governs the innovative district applications, it specifically says in the bill that you can ask for exemptions for everything but a few things, one being school finance and one being special ed, and then it specifically says quality performance accreditation. So all of the 4 that Concordia is asking for are under QPA, which is specifically stated in the statute that you can't exempt yourself from that. Here's what we struggled with, though, as a staff, is that the very first one, licensure, it says any and all regulations. That term seems to be very encompassing, any and all regulations from licensure. We don't believe that as a board you can approve that in that broad of a statement. And so we would not be able to answer yes to that. You are going to be doing something different, or it looks like doing something different with licensure, which may help with some of that situation, but that's yet to be seen in some action, possible action later today. In the second one, their desire to use advanced ed instead of QPA as their accreditation. Again, that's stated in QPA, which is specifically identified that you can't exempt from. But I think it's quite possible down the road, as you begin to talk about the 5R accreditation, that will be something that will come before this board. And quite honestly, if I were still here, it would be something that I would probably say is not a bad idea. Most of us have been involved in the advanced ed at some point and know that it is a rigorous accreditation process. But the face of the application today and what you have in front of you, we don't believe you can say yes to that. Maybe down the road. The third area, to be able to do something different in developing career and tech ed pathways, that's already possible. We believe that there needs to be some discussion with the Concordia School District as to what exactly they're looking to do. We didn't know for sure, but we didn't know if it was tied to the extra funding that certain pathway courses get, or if it was just simply you wanted to develop a new pathway. So need to have discussion on that. And then the fourth area was being able to grant PE credit for those students who participate in extracurricular activities, especially physical extracurricular activities. That, again, is part of QPA. It specifically says you can't do that. And so, again, on the Concordia one, while we believe there's room for a lot of discussion, as presented, KSDE staff would recommend that you deny the application as presented. You can see on page 51 where we laid it out in a table format, again, just a different way to look at what was requested, and those are there. So that's coming from the agency's perspective, from us trying to work through the regulations that have been established by this board. There's legal implications that I think at this point, Chairman Shaver, I would turn it over to you and see if Mark wants to weigh in on the legal side.
At our last meeting, we did ask for an interpretation of the act and legal implications from you, Mark. So do you have comments at this time?
Madam Chair, I have had an opportunity to review and analyze the Coalition of Innovative Districts Act over the last several months, because this issue has come before the board and caused some areas of concern in terms of what it meant for the board's authority and how the agency would satisfy the statutory language. It also led to a submission of a request for an Attorney General opinion. So this is something that you have asked me to do, and we have discussed in executive session and with the board on a number of occasions, as it relates specifically to the applications and the request that pens before the board. I did present you with a legal memorandum that outlines the legal justification for my opinion, but I'll just highlight a few of the kind of the general principles that I've shared with you that I believe are implicated by the Act as it relates to these applications. The first is I'd like to point out that it's my opinion that the Act does need the approval of the board, or the applications, I should say, do need the approval of the board. There have been some comments and commentary that the applications themselves, since they've met the first step, they were approved by the governor and the leadership of the education committees of the Senate and the House, that they're already approved. The way I've tried to look at that and describe the difference or the distinction between those two steps is I'd ask that the board look at the difference between what I've described as the approval of the application, which is the first step, and the grant of authority to operate and be recognized as an innovative district in the state of Kansas according to that act. So the first step is different for the first two innovative districts. The first step, according to the act, is to go to be approved by the governor and the leaders of the Senate and House education committees. The third and subsequent applications would be approved by the coalition board. but it is my opinion that the second step in that process does require that those applications come before the board for the grant of authority, which this board has, and the statute states that the board shall approve or deny the application. Subsequent renewal applications or revocations also come before the board, and there's a procedure set forth for the board to consider how those innovative districts continue to stay in existence or are removed from existence down the road. The dilemma, however, is that the statute doesn't give a great deal of discretion to the board in terms of its plain language as to whether or not you can approve or deny the application simply because it meets the technical requirements. But it is my opinion that this board has, through its self-executing authority, through its constitutional mandate, through the cases that have decided and interpreted the authority of the board, through the various attorney general opinions, that this board cannot ignore its obligation to supervise education in the state of Kansas, and that because of the act and the language that allows the innovative district to make a discretionary exemption from various laws, not only in its application but in its decisions in the future, it really is something that, in my professional opinion, usurps the constitutional authority of this board to maintain and supervise the general education interests in the state. So, of course, reasonable minds can differ, and my opinion is just one opinion of a lawyer that spent a great deal of time looking at this. I've talked with other lawyers. There may be other lawyers that disagree. And unfortunately, in this kind of a case, the only lawyers that really get the final word is the Supreme Court to make decisions about the constitutionality of statutes. But it is my opinion that certain provisions of the Act are constitutional on their face. I don't believe that this board has the ability, as Diane's referred to exempt or permit a innovative district to ignore or set aside federal law or regulations. I don't believe that this board has the authority to set aside certain state laws that the innovative district determines is not in their best interest to follow. I believe when it comes to regulations that this board passes, there's kind of a split in the road, if you will. If the regulations are passed according to the Constitution, this board has the authority to waive certain regulations that are passed that arise from the self-executing authority. And that the self-executing authority that's been described in case law and attorney general opinions basically says that this board, because it is a creature of the Kansas Constitution, does not need statute to carry forward certain rules and regulations and make policy. It can issue its own regulations without the operation of state statutes. So you have certain independent authority, which has been described as self-executing authority. However, if there is a very detailed statutory scheme for the approval of regulations. It's under the Regulations Filing Act. That's found at KSA 77-415. And so certain regulations that this board has gone to great lengths to implement in the past, there's some of those regulations have within them the procedure to waive, to request a waiver, and others do not. And so I believe that that the board does not have the legal authority to just arbitrarily waive any regulations that this board is charged with enforcing unless it complies with the Regulations Filing Act. I have discussed with the group in executive session and with the agency and with the board leadership and with the board a number of various considerations and options and strategies on how to deal with this. I think that what I have ultimately concluded is that it was my recommendation that the board take advantage of the portion of the statute that does direct or give the authority of the board to pass rules and regulations and how to carry forward the board's policy on this issue and to establish rules to take advantage of a provision within the Regulation Filing Act and pass a guidance document. And so I have taken the initiative to at least prepare something for you to consider, debate, and discuss, a guidance document that would then set forth kind of the will of the board, provide guidance to not only the agency but to the general public and to other applicants who would come before the board in the future, because you will have applicants that will, not just these two, but you have to make that decision how you want to proceed. And then it's my advice that you do need to review the applications each separately and on their own merits and make a decision. And if you approve them, fine. If you don't, if you deny the applications, it's my opinion that the board needs to provide specific reasons for the denial, because if there's going to be an appeal of that decision to a district court, that court has to look at what the rationale was for the denial of the application. And so that in a nutshell is kind of where the big picture of where I've come down, and those are my recommendations. I'd be happy to stand for any questions on any portion of that.
So, Mark, in effect, the guidance document provides us with kind of a roadmap of how to move forward and what rules and regulations we should lay out as our procedures and so forth.
Yes, and a guidance document is not something that is, I mean, it's designated by the board as precedent, if you will, on how you're going to approach certain policy decisions. It doesn't carry the weight of law, but it also allows you to take an intermediary step and not go through the whole administrative regulations process to establish the rules and regs that you will need to follow in analyzing and reviewing these applications and other applications.
Since this is a new and controversial in many respects issue, it seems to me that we do need some guidance to help us move forward. So I'll ask for board questions at this point. I see that Steve Roberts has a question.
Thank you, Madam Chair. For Mark, in preparing your guidance document, did you look at the travails or difficulties when charter schools came about 20, 25 years ago? Was that part of your research?
I didn't specifically look at charter schools. I did research a number of areas, but not specifically any legal challenges to charter schools, but looked more at the overall authority of the board, the cases that have construed the authority of this board, Attorney General opinions that have commented on it, the plain language of the Kansas Constitution, the Act itself in great detail. So,
Jim McNeese.
Thank you, Madam Chair. Point of clarification, this is a report only. There'll be no action today. Is that what I'm
It is listed on our agenda as a receive item, yes.
And will that meet the deadlines and requirements of the statute?
I'll ask our attorney or our commissioner about that.
I can comment that under the statute, you have 90 days to take formal action. According to when the board received the information and was asked to, the clock started ticking, and I believe that you have until June 18th to make a decision that would be within the 90 days, and that would fall after the June board meeting. However, if the board can reach consensus on it, I think you're better off to move and make a decision this month if you're able. But there's a lot to consider and discuss, and so I think it just depends on what the will of the board is if you want to take an action this month. And the board policies do provide for if you want to take an action in a month where there's information only, the board policies permit you to accelerate that.
And that would, I believe, take a vote of the board to do that? To suspend our rules and vote on it today?
Jim, repeat what you said. I was thinking about something else.
What Mark said, we could go ahead and vote on this today. But I'm just asking the question, would a new board member, do we have to vote first to suspend our rules?
Yes,
to be able
that's
to
the
do
process.
That would be the first thing we'd have to do.
Right.
Okay, thank you.
Are there other comments, other questions? Janet Wall.
Thank you. Mark, I just have a clarification question. In this document, the one entitled guidance document of the board, is that the violation looking at the correct document? Yes. Okay, that's the one I'm looking at. That's all I want to know. Thank you.
Just as a follow-up to that, I had originally labeled it resolution just because it was something that I'm familiar with in terms of the board kind of taking a formal position. We moved towards the calling it a guidance document because it's a term of art within the Administrative Regulations Act, and I think it fits what at least I heard many of the board members expressing that they wanted to have some guidance on, as a board, collectively, some guidance on how to not only evaluate these applications, but to deal with this issue that will come before the board in future applications. So it can be changed and modified at your discretion, but at this point it's just in draft form. It's called a guidance document of the board.
You say in draft form, does that mean you see that there might be needed revisions, or that it would be possible to approve it in the form you have given it to us in?
It's draft only in that I prepared the document, and it's received some input from the agency and from others have had an opportunity to provide some input. It could be adopted as is, or if there's specific language that you want to tweak, then I think that would be whatever's necessary to get your 6 votes, I think.
I feel very conflicted on this issue because we have supported innovation in the past. When Randy came to us several years ago, we were behind that effort. We sent a letter with the waiver so that we could help promote that with the feds. And so I think all of us want to encourage innovation in our schools. The question is how we can move that initiative forward. How can we be collaborative with the districts that really have ideas and are forward thinking? So that's kind of our dilemma right now. How can we move this process forward, collaborate with the districts, and yet retain what we see as our constitutional charge to oversee education. So are there comments from any board members about how you would like to proceed or move forward? Ken Willard.
I only intended to be on there once. I see I'm on there twice now. But
Ken, can you move your microphone closer to your mouth?
I just don't think you like the sound of my voice, Jana.
No. I like to hear your voice.
It will be no surprise to anyone that I view this a bit differently than what's been presented today, because as I hear the presentation, the legal presentation of what we can and cannot do, it seems to me that the only thing we can comfortably do is say no, because we didn't initiate it in the first place. And that's troubling to me. We say we like innovation, but unless we put it into place and initiate it, we're very, very reluctant, it seems to me, to allow anything to take place that we have not already blessed. And what's being requested here is not, well, it seems to me the only way that these schools can comfortably go ahead without thinking they might get sued is to wait until we go through the process of developing regulations that would accommodate what they want to do, so they don't have to ask for anything. Now that may be not accurate, but it seems to me that I'm just uncomfortable with what appears to me to be extreme reluctance to support this innovative district idea. These districts are not asking for us to change our regulations or modify our regulations for the entire state, for all schools, but just for these specific instances, to create these labs of, hopefully labs of excellence or labs of innovation that we can observe and approve or not approve as they develop. But it seems to me that we're being far more restrictive than we need to, and the attitude is that we've kind of look to see how little we can give rather than how much we can support the effort. That's a generalization, I know. But I know when I was on a local school board several years ago, we went with North Central as our accrediting agency, and that was not a problem. Now, somehow between then and now, it is a problem. And so advanced ed is not, we can't approve they're using advanced ed for their accreditation rather than ours. Is that what I'm understanding? So that again, it just seems to me that we want to maintain such tight control. I'm not so worried about the challenge to our authority because we're not challenging our authority over all schools, but just the challenge is to open up the door for more innovation in a few isolated districts. While there are 28 that are possible applications that could be received, I suspect there will be far less. And if we effectively shut the door on these two first districts, there won't be any more, because we've effectively said none other need apply, because we're not going to approve the first two districts that are hopefully going to set the pace or the standard for what comes behind them. So I'm one board member only who is not supportive of the effort to try to slow this down. I think that we ought to be looking for ways that we can accommodate them. If the wording of the application is a problem, let's visit with the school district and say, is there some better way that we can word this to grant you the authority that you need so you can move ahead and not wait for us to go through months of haggling over this and regulation changes. So I'm very hopeful that we can see a way to bless this limited effort for innovation. You know, we have charter schools supposedly in this state, but they're so limited that there really are no charter schools. They're just schools who do a little something different in their school. And the reason that this innovative district idea has come forward, I think, is because we have maintained such tight regulation over innovation in our state. And that's not a criticism, that's just an observation of mine. I think that we have such close control, tight control, that schools feel very, very inhibited to do different kinds of things. Concordia wanting to waive their kids from physical education classes, some of their kids from physical education classes who are in sports, maybe 3 sports throughout the school year, seems to be a totally reasonable kind of thing, but it doesn't fit in our current regulations, so we tend to say no, and that's troubling to me. So I think we ought to take a much more liberal approach to this, and see if there's not some way that we can grant our blessing to this effort. Thank you.
I don't believe anyone on this board wants to be in a position where we feel like we are slamming the door in anyone's face. We are trying to work through a difficult issue and find a way of collaborating with these districts so that we can all move forward with innovation, and we have always supported innovation. Our hands are tied in some respects. We cannot waive federal law or federal requirements, and there are other things that are issues here. We're trying to figure out a way to work around this. I'll wait to make a suggestion I have until I hear from some of the rest of you. Sally Cobble.
Thank you, Madam Chairman. I feel like a little bit of a person that has been pushed back into the corner and I don't have any good way out. And, but, you know, we all took an oath when we came on this board. And I think our attorney has done a good job to protect us for doing our job according to that oath. Now, if I go ahead and accept this guidance document, I have 2 questions. Can we not, as a state board, come back and do something to help these districts? We could develop our own innovative districts, put all of them in it, and listen to them. My concern is that any action that is taken on an innovative district that we have no say in is that it could affect other school districts that are not in it because of federal funding also. And sometimes our consequences, our unknown consequences, are more of a problem. And I do think that across the state, I have many districts that are already doing many, many innovative things and are able to work within the parameters. Do I think there are some things that I'd like to see done differently? If we could waive some things, yes. But I do not believe that the way in which, I just don't believe this Innovative District Council is the way to go. And I'd like to do it a little different. So I'll be supporting the guidance document, but it won't be the end of what I want to do about innovative districts. I think we do have the responsibility to be a little giving, and because we want to see what can be done out there outside the box. And I think we're going to have to look at that one situation at a time. As cumbersome as that is, I think we're going to have to do that. My question to our attorney is, once we sign, if we adopt this guidance document, so what? What's next? I'd like to know the outcome of signing this document, or the, what's next?
Well, as it relates just to the specific guidance document, the regulations do, or the statutes do say that you have to publish it. You have to put an index of any guidance documents that the board has on its website. You have to file this with the Secretary of State's office. So there are a few administrative things that would need to be done as it relates to just the file, the signature and entry of the guidance document. But, you know, it can be changed in the future. You can have other guidance documents. As your question relates to what's next in terms of innovation, I think that's only limited by your own imagination and only limited by what the board is willing to take on in terms of possible other solutions to come up with the issues that you've described. So I'm not sure if that fully answers your question, but okay.
If I may be allowed to ask a follow-up question, in House Bill 2319, Section 10 says that the state board shall adopt rules and regulations necessary for the implementation and administration of this. Would the guidance document take the place of the rules and regs, or does the board still have to go through rules and regs according to what's listed in the bill?
That's a good question. I mean, you could go further and you could develop specific rules and regulations that were either an extension of the guidance document or something different, and so you could take advantage of that part of that subsection of the Act and go ahead and introduce regulations that would go through the normal process. So, for example, if you had some ideas about working with the requests of these particular districts, or you wanted to establish a mechanism to waive certain requirements, you wanted to put due process into certain regulations, you could go forward and do that. It's just that the administrative regulation process would take much longer than, you know, the 90 days you're required to consider these specific applications. So you're not, this doesn't limit you in any way.
Dina Horst.
Thank you, Madam Chair. Well, I too have some confliction with this whole process. And a lot of that comes from having been a legislator. And I guess I can equate this to some, when I read the Constitution, to me, as a legislator, it says the purse strings belong to the legislature, not to the court. And so, as a legislator, when Montoy came down, we had no choice but to follow what the court had said. And I see this in a similar fashion, that while we disagree with some of what we think has been taken away from us as that's constitutional, I think we have an opportunity to reach across the table. And it's much as the legislature did with the Gannon. I think when you look at the difference between the Montoy decision and the Gannon decision, it was more of a collaboration, even though neither of them were talking. I don't think they were anyway. But still, in this arena, it seems to me that we can still say we think that it's that the innovation, the way this has been set up, is perhaps an infringement upon our authority. But I heard from two people last month a hand being reached across the table to say, come and work with us. And instead, I'm concerned, as I've mentioned to some of you already, I'm concerned that if we say no, we've shut ourselves potentially out of collaboration with folks across the street. And how many districts are going to see us in a different light? That we're not really wanting to work with them. And I think it's important that we consider that fact as we look at this picture. There are a lot of things that in the guidance document that I appreciate, and I like kind of the way it's stated because it says some of the things I feel. But I also know that there are other districts who are just waiting to have the opportunity to join this group as well. And do we have an opportunity to use them, this innovative district idea, as a pilot for things that even some of us would like to see happening in schools? And it seems to me that if we have some regulations that don't say there's a way to waive them, we should go back into those regs and say there is a way, so that all those things could be outcomes of our collaboration, which I appreciate the term that the chair is using, our collaboration with the school districts. And I think it's important that for the good of schools, for the good of kids, that we're all working together and that we're not shutting down any option. And I do have a question for our attorney, because when I read I guess it's section, I'd have to go way up to see where it is, but it says, if the state board determines such application is not in compliance with either of these sections, it shall deny the application. Well, I'm not sure. I know that the State Department went through and said, well, they didn't really address this precisely, and some things we can't waive, and so therefore we should deny. But I guess when I read through what the application says, it doesn't speak to not being able to actually waive things. It just asks, what are they wanting to do? Did they answer the question? And I guess I would have liked to have had the opportunity to have sat down with the districts and said a little more, what did you have in mind here? But that isn't a part of the law. So, and it wasn't part of the application as far as I could see. So I guess that's part of my question. If we deny, on what basis, according to the law, can we deny?
I believe you partially answered your own question in that it is not part of the law, and I acknowledged up front that it doesn't appear that there is a great deal of discretion in the plain language of the statute, but it's my interpretation that, and in my opinion, that doesn't necessarily mean you don't have the ability to look at this law and make sure that it's consistent with your authority as granted under the Constitution. And so you were citing from a specific reference in 72-1923 that says within 90 days from the date such application is submitted, the State Board shall review the application to determine compliance with this section and shall approve or deny such application on or before the conclusion of the 90-day period. It also says if the application is determined to be in compliance with this section, the State Board shall approve such application and grant the school district authority to operate as a public innovative district. So I believe that the feedback that you got from the agency was that there was a technical compliance in that it met each of the application met each of the subparts that are required of the application as designated by the statute, but that the request for waiver of certain laws either were not practical or were not possible based on the things that they were asking to be waived.
And I guess I could say I get that, but my concern is that, and maybe I'm reading the law too black and white, but it just seems to me the law says one thing and we're expanding it, and it's under our authority as from the Constitution that we're expanding it. Is that what we're saying?
Well, I think two parts. I think that the specific request to waive certain laws and regulations, it's the conclusion of both the agency and council that you don't have the legal authority to do that. So if you were to just rubber stamp it based on only on the satisfaction of the four technical elements of the application, then your grant of authority would send a message that you're giving authority for everything that's within the application. And then that's where it kind of opens the door to the issue of, well, do you have the ability to grant that authority in areas which you believe shouldn't be or cannot be granted?
And I understand that. Can we approve with the understanding that we do not have the authority that along with that approval does not come with our approval of necessarily the content of what they require or requested to be relieved of.
I guess it's possible. I think it would send conflicting messages that you're granting approval for one thing and not granting approval for another. I'm not sure I'm following completely your question, but you could say that there has been a technical compliance and that the application, as specified by the statute, did meet the 4 criteria that were required in the application. But my concern is that the grant of authority, once you grant that authority according to the plain language of the statute, you no longer have any say, and you're endorsing the innovative innovative school district, and they are not required to come back to you for anything. They can waive at their own discretion in the future additional laws and regulations, and so it's inconsistent within the statute itself. And on that basis, I'm making that determination that you have to rely on your own authority to determine whether or not you want to approve it and give that stamp of approval, or whether you want to assert your authority at this stage.
So it comes down to whether we trust the districts to continue to work with us, or not, in a sense.
I don't think I'd characterize it that way, because I'm not passing any judgment on whether anyone is trustworthy or they say what they mean. I'm just saying that according to the plain language of the statute, there's no linkage between the board. There's no requirement that they go forward. So I respectfully would not characterize it as an issue of trust. I'm trying to look more at the plain language of the statute.
And I guess I'm just interested in the collaborative component. So,
well, and that's why I'm going to interject something before I call on Janet and Sally, because I've been thinking about this issue a lot and how we can move forward. Here's a suggestion that I have. I want to throw it out there and see how you feel about it. I would like to appoint a subcommittee of our board to meet with these 2 fine people who have come to talk to us, who have ideas, to talk about their applications, maybe elaborate on the areas that were kind of problematic, to have a conversation about it, and then come back next month before we actually vote on the applications. Maybe we could clarify some issues. Ken mentioned QPA years ago and how if a district had North Central accreditation, that was fine. Well, that was because the board agreed that if a district received North Central accreditation, that would satisfy the QPA requirements. I was a chairperson for over 20 schools during that time. So there are ways of working through these issues, and I think until people sit down and talk about them, you don't have a good sense or idea of how you can move forward. It's not easy. It is not an easy issue. We all know that. But anyway, that was kind of my suggestion for how we might proceed. Personally, I like the idea of the guidance document because it kind of outlines, a process and why we feel that this is the process and the authority that we have for moving forward. So those are my comments. You can think about that for a minute while Janet and Sally make their ask their questions. Janet Wall.
Thank you, Madam Chairman. Your comment brought to mind something I was going to say, so I can maybe put it together. Excuse me. But first of all, I see no way that this board, or I want to start off with, I guess, a negative, I guess you want to say, how we can possibly approve anything federal. I mean, I cannot personally risk federal funding to these two districts, or any of the innovative districts, or the whole state. I can't risk us losing the waiver. Both of those things to me are at risk when we start waiving federal law. So I'm very, very concerned about that. That's my number one thing. I'm very concerned. Excuse me, so I don't believe we could do that. As you all know, I served on a local board many, many, many years ago, and one of my big hang-ups was state and federal law. You know, and so that's why, as a state board member, I have every single time they've come to us for a waiver, approved it. Yes, let's do it. And to my knowledge, I don't ever recall us not approving a waiver, so I'm very proud of the board on that. But back to this innovative district thing. My first thought was, well, you know, tomorrow we're going to have the meeting on the QPA and looking at the new accreditation model. And I like your idea of maybe looking at piloting some of these things, you know, and maybe these districts, we could look at what they want and maybe they could pilot some of them. But then my next thought was, and this maybe would line up with yours, I would like to suggest that maybe what we can approve, what is state, you know, in our regulations, that we possibly could do, maybe if the districts would come, my thought was that they would work with the department and bring us a presentation next month, but we could add to that and maybe have a couple of board members attend those meetings with the department, because I think we need both sides, and then work back, and then they could come back with us, and then hopefully, instead of just totally denying them, we can approve this, but we can't approve this.
Well, I forgot to mention when I made this proposal that Brad or other staff members meet with that group. I didn't mean to exclude the department, so thanks for that reminder.
Well, anyway, I had that suggestion down, but anyway, I like the idea of board members possibly attending. Thank you.
Sally Cobble.
Thank you, Madam Chairman. What you recommended was what I was going to suggest, that we don't just sign this guidance document and make the end of things, because I think we all want to do. So what would our next step be as a board? I would like for us to form some, how it happens, I don't know, but form some kind of committee. Because the one thing we always talk about at our board retreats are, what are the barriers? What are the barriers? And I think we're all wanting to find out what the barriers are that keep these districts from doing what they want. So that's why I'm very much for an innovative council of some kind. I just don't think this innovative council is the right way to do it. So I would like for us to develop our own innovative council and work with and help come up, because I think as these school districts want to be innovative, what is it that's keeping them from doing? You know, you go around, you talk in the districts, I've got districts that are having problems with the times that we open up for testing. Well, you know, they want to waive that. And so maybe, you know, we think we've listened to districts, we think we're listening and doing some things, but maybe this would be a good way to bring that together and see what. So I like your suggestion. Once we vote on this guidance document, if it happens to pass, I don't want that to be the end. I want us to go on to something like that you suggest, and maybe we do it all at the same time so we have a direction.
I wasn't proposing anything as formal as a council at this point in time. I felt like there needed to be discussion and collaboration between the two applicants, board members, and the department to try to look at these issues and see if there's some way of working together to come up with a solution to, well, this isn't within our authority but to waive, but how could we change it? I think down the road a council might be a good suggestion, but mine was a kind of a 1 month temporary collaboration and discussion so that coming back to our next meeting.
I went from A to C.
Yeah, well, I'm a very sequential person. What can I say? Okay, Kathy Bush.
Thank you, Madam Chair. I'm kind of a pragmatic person, and this law's been passed, and I think we need to figure out how to work with it and go forward. The commissioner pointed out the part in there that says that the state board shall, and I don't have it quoted exactly right, but shall create rules and regulations, which we all know that's quite a process. If this guidance documents, or maybe a variation of it, does that, I think that's a good thing. And maybe with a little study of this little subcommittee, the innovative districts have already offered to want to work with us, so I think there's some good potential for collaboration there, so maybe we can get together to work on those things and come back with a recommendation next month from a subcommittee. I think there'd be some good things. I do agree with Janet. I do not feel like I can have the authority or don't want to personally take the authority to waive federal law. I just don't think that's something, I'm not willing to stick my neck out there that far, quite frankly. So I think there's some things we probably can't waive, but I do think we really do need to look at innovation and to look at these districts as an opportunity as a lab setting to try some things that we're potentially interested in, they're potentially interested in. I think it's a very powerful thing. It could maybe help guide us as we look at future changes. So I think there's a lot of potential in this. We just need to figure out how we're going to work together on it. And I think your idea, Chair, of putting together a subcommittee is a good one. And I know that's a tight turnaround, and it would be up to you guys to, if you can do that also, if you're willing to be able to come back next month with some recommendations. I think that's a dandy idea.
Mark Ferguson, thank you, Kathy. Mark Ferguson had a comment.
Madam Chair, just to highlight two of the provisions in the statute that you can work within based on what the discussion I'm hearing is, first of all, 72-1929 is the provision that requires the state board to provide technical assistance and advice. So it says the state board shall provide upon request any board of education with technical advice and assistance regarding the preparation of an application for a grant of authority to operate a public innovative district. And I know that the agency has provided technical assistance, but that could be part of what you're trying to do in the next 30 days, and if there's necessary for an amended application. There was a question about the rules and regs. There's a separate provision that states that the state board shall adopt such rules and regulations as necessary for the implementation and administration of the act. So then that would give you the authority to work on more regulations. Just to throw out for suggestion from what I'm hearing is since you have 90 days would expire on June 18th, if the board were to make a decision at the June board meeting. Also, you do have in the statute a reconsideration process. So if in that 30 days, in the next part of this process, if the board were in June to say we can't approve as submitted, but if the application was amended and the districts were willing to submit an application, a reconsideration and modified application that met the parameters of what the group that you're talking about has defined, then you would have, after the June meeting, you'd have 60 days to also consider a a request by these districts to reconsider the board's decision and modify the application.
Thank you. That gives us a good idea about timeline. Steve Roberts.
Thank you, Madam Chair. I just want to reiterate to Bev and Randy that you have my full support, 100%. You have since you begun this. If you're ready to speak at this time, I'd love to hear from you. If it's not the right time, I can appreciate that as well. We've got some serious haggling over constitutionality and our responsibilities, and I'm sure you can appreciate how this board wants to protect its own integrity as well as work with the people across the street who realize that while we have children dying on the vine, we have to make some changes. I just want to say that in a previous life, when I was an environmental engineer, I tried to tell people that my work was paralegal because I couldn't apply the math and science to solve all the problems. I had to basically start with the law. Even if I was incinerating PCB-contaminated soil, I had to start with the law. It always got back to the law. But we had language in the law that gave us enough flexibility where we could actually build a project and not have to worry about whether or not every T was crossed every single moment of the day. And we need that now. We need that now. And so I'm going to support the idea that the first two innovative districts have already been blessed, and that future innovative districts need to be blessed by us. Thank you.
Dina Horst. Dina Horst.
Thank you, Madam Chair. I, too, would like to say I appreciate the idea of having a committee to work with the two districts. I guess I still have a question about how my approval of their applications would somehow say I'm trying to waive the way they're stated. I don't know that it says I'm waiving anything. I'm approving those two individuals to be a part of the coalition. And I guess I'm trying to look at how the details have somehow become the reason why we can or cannot approve. And I guess perhaps I need a legal opinion on why that is, because approving the application to me is not necessarily saying I agree with the fact that, or that I'm saying I'm going to, or we as a board are going to waive federal law, for example. I think they're asking for that, but I don't think it's requiring us to do so. But maybe my read of their applications was incorrect in that manner.
I think that the applications as submitted are requesting certain exemptions from law, and so if you, my interpretation is if you approve the application, you're giving your blessing or your consent or you're granting authority to operate according to the parameters of the application. That's my opinion.
So if they would reword the application in some way that
depending on how it was reworded, it
would
may or may
not
not
hold us to saying we were waiving. So we were not actually saying that, or in other words, putting in jeopardy the funding, potentially all federal funding for the state by doing this. So if they could reword it so it wouldn't necessarily hold us, make us responsible for the waiver.
I think that each application has to be reviewed on its own merits, and depending on how it would be modified, it may or may not be objectionable according to the interpretation that I've given you. I do think that you have to go back to the basic premise of the Act, which gives them the authority to make those decisions. So there is some inherent concern that I've expressed with regard to the lack of linkage or the unconditional authority that you're granting these public districts. But to the extent your question is asking, could an applicant modify the application to the point where it might satisfy the board? I think that's possible, and I think it's what is being suggested by other members of the board, that in a collaborative effort, of course, we're presuming that they want to modify it to overcome those concerns and objections. But if everybody collectively had that goal in mind, then that application could be reviewed on its own merits.
Okay, thank you.
John Bacon.
Thank you, Madam Chair. We've got these applications in front of us. There's on the rubric or the chart, there's specific requests, and then there's the department has responded to those, saying that there's not enough information, that we need to get more detail. The applicants are here. Can we ask questions of them in regards to some of these requests so that we can get clarification today to vote on this next month?
Well, we could. I thought that would be time consuming. That was why I suggested a subcommittee of the board to meet with them and work out some of those issues and bring back a report.
Well, I mean, it seems like we've wasted a lot of time bloviating on stuff that really doesn't matter down in the weeds when we need to get specific on these two applications that are before us. So I have specific questions.
John, one thing too is both did present last month to us, and
that.
so we kind of asked some specifics on that, but so just wanted to make sure that you were aware.
I was not, so I apologize.
But, I mean, that doesn't mean you still have more questions.
Right. My specific question has to do with McPherson's request for exemption of regions and how that permanently affects.
Go ahead and ask that question. I think we did discuss it, but I just don't think we have time in this meeting to go into a long list of questions. But please, since you weren't here, ask your question. Oh, well, yeah. Randy and Bev, are you prepared to respond to a question from John? Okay.
Well, I guess it would be for Randy then. If he's, what specifically are you asking an exemption from for regions? Long-lasting impacts on students wanting to go on to Regent schools with this exemption. How does it affect them, if any?
I think specifically what we were wanting to look at was the idea that if you take 8th grade algebra at a middle school, it doesn't count for Regents credit. Okay. If you take that same course at the high school, it does. And it has to do with the location of which it actually takes place. So I think direct response to that, that would be the one thing we'd want to look at.
And so have you heard back from the Regents institutions to find out if that works for those students?
No, sir. We haven't proceeded at all. We came to this body to proceed. We haven't moved at all with any of that application process.
Can you get, within the next month, could you get just an idea of where the Regents might land on that issue and whether or not that credit would count for those students?
Yeah, we certainly can try to do that. I don't know. I think you'd have to, I don't know that you've given us that authority to do that yet. And yet, I think some people would say we already have that authority. I think that's what you're wrestling with today. But if you as an entire board would ask us to do that, I think we would be happy to do that. We don't want to do anything that upsets the State Board of Education. And maybe we just haven't made that as clear as we want to. So we'd be happy to do whatever we're directed to do.
Well, if I'm approving your application and then we find out students aren't going to get accepted into the Regent schools because they're short of math credit, that's important to me to know before I vote. So if there was a way that we could get an initial reaction to that from the Board of Regents so we know whether or not they're going to qualify for admissions, that would be great. Thanks.
Yeah, and in line with that, since the Act does refer to technical assistance from the department, you could work with the department in seeking that information. But from my perspective, that's strictly a Regents issue. We don't have authority over that, but the answer to that question is important. So I think there are ways of getting that information. But along the same line, would the idea that I had about sitting down and having collaborative discussions before our next meeting to kind of try to work through some of these unknowns or some of these difficult issues or so forth, would that be something you'd be willing to do, or where are we with that?
Sure. As I expressed to you before personally, that yes, we'd be happy to sit down and do that. Our thought, Bev and I thought all along, and I don't want this to be missed in this discussion, is to sit down and talk about the barriers of innovation in general and how we can work together to remove those. We know I know that this state board or a previous state board endorsed us going forward with the federal government. I know you alone can't do that. But to have a discussion about that process and whether or not we want to go to, that's what we're really after. I understand all the dilemmas that this law causes for you legally. But we hope that we could just start a dialogue of not so much the very, very specifics, but what are the things that we could agree to go forward, and when do we need to fight a battle above us or across the street, in order to do that together. That's what I think we see going forward. So yes.
And I would agree that that's important, but we have an issue right now that we need to move beyond in order to get to those bigger discussions and those more important discussions, I think. So, Jim McNeese, were you?
Thank you, but I'm going to hold off for, other than to say we've been fighting the Regents for years on that. Been there, done that, and failed. Happy to help. I'll wait till later. Thank you very much.
Okay. Carolyn Campbell.
Thank you, Madam Chair. Well, I'm sort of tacking on to what John asked about the 8th grade and the Regents, and you said that if we directed you to or how did you made that comment to maybe, I thought you said if the board would ask you to find out if what the board's Regents stand would be, and I was thinking, did I misunderstand you then?
I hope I didn't misspeak. We submitted an application as we thought was defined by law. We haven't gone forward with any of that further discussion because it's been pending before the State Board of Ed.
Thank you. Then my thought was that if I were in the district, isn't that a question that I would want to maybe know? That can't you go on your own, check with the Board of Regents to see what the decision was? I hear what Jim McNeese is saying now, that good luck, but I just don't understand why you wouldn't maybe just call Andy Tompkins or his office and just ask them to, what their position would be, or if they could review it. That's all.
Ken Willard.
Thank you, Madam Chair. This has been a good discussion and helpful, I think, in some regards. And John's question regarding the Regents question, I think, is a really good example of why we need to be demonstrating support for this innovative district idea. Jim just said, I fought that battle before with the Regents and lost. Randy can fight that battle till he's blue in the face or till he retires, and he'll lose. Because we've established an immovable barrier by saying we won't do anything because we're going to let the Regents pass on that. We have an opportunity here that we've not had, in my experience, where we have the legislature behind this idea, we have the governor's office behind this idea, and that is the way, I think, and hopefully we have the board behind this idea. That's the way that we can move some things and make some changes at the regent level, possibly. Rather than just expecting a school district to fight that battle on their own, there are things that need to change here. I think we would all agree with that, maybe. There are things that need to change at the Board of Regents. I think we would all agree with that. But if you just require every school to fight their own battles because we love local control so much that we don't want to help them, then they're going to be perennial losers in those kinds of fights. So I think this discussion, while it's been interesting and maybe helpful, is really farther into the weeds than we need to be today, because the specifics are going to come up down the road with these other districts. And these pioneers are going to be cutting the wake and giving us direction and helping us with working through those issues that these other districts are going to face. But I think again, we have a unique opportunity here, an unusual opportunity to get behind this rather than ahead of it and trying to stall it. And I don't really think that's what most people are trying to do. But let's not get so far into the weeds that we can't say we bless this idea and we're going to work with these school districts to work with whatever problems they're going to face with the regents or whomever and see this thing proceed.
I think your comment about support is very valid, and I believe all of us want to support our local districts. That is why I suggested a format for an initial collaboration and discussion. Jim McNeese.
Thank you, Madam Chair. I'm back. I'll make this quick. I have a couple questions, and Mark, they're for you. If we were to approve these two districts, at any time, today or next month, it is my understanding that they begin their authority and their operation as the innovative board. And is that correct?
Yes.
Okay. Second, they, as a board, Bev and Randy are then the ones that approve the applications in future for future applications and make the decisions on yay or nay on who's in the 28 club and who's not.
It's been highlighted that there's a difference of opinion about what that first step, but it's my interpretation that they would be the ones that would approve the application, and then the application would come to the board for a grant of authority to operate as a innovative district within the coalition that would be approved. So the next, the third and subsequent applications would go to the.
And then they begin to operate as a board, and they're complied, I believe, to meet monthly?
I believe that's what the statute says,
yes. Correct? Okay, and then they basically oversee and they are the ones who become the innovative board, and we are basically over here. They've invited us to be on that board. Thank you very much, but they were not obliged to, nor are we. We're only here to help them, give them help. Is that correct?
There's no requirement in the statute that
we help
that links them. There is a requirement in the statute that we help them.
Okay, but
that we provide technical assistance and that we can have the authority to pass rules and regulations. But
what happens is they become a board, to run the innovative schools, and the Activities Association is required once a year to come back and give us a report, but they're not. They're not required to do anything other than operate, and after the third one, as you said, and they basically are an independent board.
I think, yes, I think there is a reporting requirement to the legislature.
My point is, I want to help them as much as I can to be innovative, but I do not want to give up the authority of this board, as I said at the last board meeting. That's my contention. My problem is not with the innovative and the great leaders that we're sitting here before today. My issue is solely in establishing an independent board. If we were to find some way that we had a relationship with this board, other than their invitation, which I appreciate very much, similar to or a part of, like we do with the School for the Blind or the Deaf, or we're even looser with the Activities Association, but my dilemma is how to support them but not give up the constitutional authority that's been granted to this board. And that's where I'm from, because I want to fight the fights. And by the way, there are the NCA thing, Advanced Ed. When did that change? I've been doing Advanced Ed my entire career. That's never changed. We can still do it. We can still do that. Heck, I was asked to be on a team leader the other day. There's just a lot of questions like that sometimes we get lost in. But my biggest issue is critically that we're establishing a board, and we're granting them the authority from us to operate as a board, and we're just we're giving that away without any what I would call appropriate stewardship on the part of we as board members. Not that they would do anything wrong. I mean, these guys are smart, they're great, they're good. I trust them without a problem, but I just don't want to give up that authority to fulfill that stewardship role that I have as a board member elected by the people in District 10. Thank you.
Janet Wall.
Thank you, Madam Chair. I would like to make a motion. I would like to make a motion that a committee be formed, a committee be appointed by the board chair to work with the department and these districts to work together. I wrote it properly for me, Peggy, to work together to come back with a recommendation at our next board meeting of hopefully what we can approve. And I don't know.
Moved and seconded that we appoint a subcommittee to work with the innovative district chairs and superintendents, to discuss the applications and bring recommendation, and let's not to meet and collaborate and try to work through some of the issues that are out there that have been identified as problematic on the applications. I probably didn't. Okay, and Dina seconded that motion. Is there discussion? Ken Willard.
So is this committee going to be working through all the details of the weeds that we've been in about each individual waiver that they may want to implement in the future? Or is it going to be to address Jim's point and that was some sort of accountability, maybe quarterly or semi-annually or annually back to this board, a report of what they're doing. That, because I don't know what the committee's going to do. If the committee's going to be going through this, they're going to be in this same struggle when they come back.
You know, I don't think we can predict how this group can collaborate and come to some solutions or agreements. I don't have a crystal ball on that, but I think until parties sit down and look at the issues and discuss them, we can't always see the path forward, and I think that may help us see how to move beyond this point and move forward. I don't have an answer to that question.
Thank you, Madam Chair. I didn't make myself clear. I'm just not sure what the charge of this committee is. Is this committee charged, if it's formed, is this committee charged with working out all of these questions that we've been discussing here today and coming to a final resolution of those? Or is it to figure out some method of accountability for this new board that's being created to report back to us so we're not giving up 100% of our supervisory control?
I think it could be both. My purpose in suggesting this was to give us a way of moving forward, of having some recommendations about how we might be able to look at these issues in a different way, and having creative solutions to a very difficult situation. So I have seen wonderful things happen when people sit down and talk and collaborate. So at this point, I cannot predict or give a specific charge on you need to do this and this and this. Would you have a better answer? About the role of this committee? No. Okay.
I agree. I think it's going to be a little bit of both. And part of what we'll confine doing the second part of what you talked about is that it's very specific within the bill as to some things. So even if, I think eventually down the road, if you decided to set up something that was more of what Jim described, where we have some say in what happens with the coalition board, you're going to have to go back during the next legislative session and ask for an amendment to this bill. So it's not going to be over. Because you can only do so much as to what's within the bill, and it's quite possible that Dale's going to be with you this afternoon as you talk about future legislative items for the 2015 session. This may be one, is that this bill, while well-intentioned, is pretty sloppy and needs to be cleaned up just based upon some of the discussions we've had here. So I think it could be a little of both.
That didn't really answer your question, but that's the best I can do right now.
All right, thank you.
Are there other questions before we vote on appointing a subcommittee?
Madam Chair.
You have a question, Steve?
Well, I just wanted to say I'm not behind the idea of the committee. I think in looking down the road, we would do very well to appreciate the difficulties that these two districts have already been through to get to this point, and to stand up for our constitutional authority on all subsequent districts. I think since we were founded on a system of checks and balances, I think we have most of those checks and balances in place. And I think that the sense that I'm feeling from my fellow board members is that we've been hurt, our feelings have been hurt, because we weren't consulted in the first place the way we would like to be. And being a board member who's got an ego as big as anybody else in this room, I mean, my ego is pretty big. I get too big for my britches sometimes, I really do. I just think that in order to appease isn't the right word, but to respect the folks across the street who want good schools. And the feeling of our individual board members in this room who want to innovate, I think we should go ahead and take, dare I say, a leap of faith that the first two districts have gone through several measures to this point and have met initial tests to become innovative with our approval. And in the tussles to come, because there will be tussles to come, we will have the gumption, I don't know what the right word would be, to stand up for protecting Kansan families with our stewardship of Kansan education. That's our role. And to feel that our role has been usurped simply because, 418 and 333 have been granted some authority that we didn't give them in the first place, I think we should swallow that. I think arrogance is getting in the way of good sense sometimes. Like I say, sometimes I get too big for my britches. I realize that. But for God's sakes, people, use your ego for Kansan families and not for the aggrandizement of this board, please.
And Steve, I'm going to have to respond to that because I do not see this as an emotional issue. I see it as a logical look at what the Constitution says the state board is assigned, required to do. To me, it's not an emotional issue. I want to be sure that we are following our charge to do the best that we can to provide an excellent education, a quality education for every student in the state of Kansas. Whatever that involves, whatever regulations are involved that we know are in place, we have to consider. To me, it's not an emotional issue, it's a logical issue. So,
clearly for me, it is an emotional issue, Madam Chair. I've been at this for 30 years, and we're getting close now.
Well, we all have passion for education, or we wouldn't be here. I'm looking at the clock. We have a full agenda this afternoon. I believe we need to vote on this issue so we can move ahead and have time to prepare for our afternoon session. But Ken, is there something you must say before we do this?
Yes, ma'am. It is this, that I appreciate your offer of the committee. I think it's a way to move forward without saying no, and I'm going to support it with the stipulation that I want the committee to be focused on how to move us forward and not how to let details stall it. I think this committee needs to lean a good deal more closely to what the scenario that Jim McNeese forwarded, and that is approving this board to operate these schools rather than us trying to work through all the details and every eventuality and every possible challenge to current regulations or laws. So that's a little more wordy than it needed to be probably, but I'm going to approve the committee because it's not saying no, and it's giving us a chance to move forward and approve this innovative board. Thank you.
Thank you. Are we ready to vote? All in favor of the motion, raise your right hand. I see 9 hands, all opposed. Opposed by Steve Roberts. So the vote was 9 in favor, 1 opposed. At this point, we will adjourn for lunch and reconvene. Oh.
Are you going to come back to this?
Yes, can we, who's free? Kaylin, will you be here after lunch, or do we need to do this right now? Okay, let's move forward with this agenda item. I'm sorry. I was so caught up in the discussion I didn't look at that. We are going to act on the recommendation of the Professional Practices Commission.
Thank you. This should be quick because there is only one application before you this month. As you can see on page 123, the Professional Practices Commission voted 6-2 to recommend that this applicant be granted a license. And so I stand for any questions.
Are there questions? Are there questions? Then do I hear a motion that we adopt the findings of fact and recommendations made by the Professional Practices Commission regarding the licensure renewal application submitted by Stephen Goggin? Moved by Jim McNeese. Seconded by Sally Cobble. Discussion. All in favor, raise your right hand. Oops. 1, 2, 3, 4, 5. I see 6 hands in favor. All opposed indicate by raising your right hand. Opposed by Dina Horst, John Bacon, Ken Willard, and Steve Roberts. Thank you. Now we will adjourn for lunch until 1:30. Recess, not adjourn. Recess for lunch.